code, it is absolutely at the school's discretion to deal with that issue as they feel is necessary. However, because Ms. Carter's hair was political speech protected by the First Amendment, the school cannot simply prohibit her speech just because it violates the dress code. They must prove that there was a material and substantial disruption. And although students may have repeatedly played with Ms. Carter's hair, there is certainly no evidence that this ever rose to the level of a material or substantial disruption.
As you know, the school has indicated that one of their concerns was that the type of hairstyle she had was associated with folks who were selling drugs in the school. Isn't that an important thing for the school to try to protect other students against things like drug activity?
Yes, Your Honor. As this court stated in Morse v. Frederick, it is absolutely a compelling interest of the school to prevent students from advocating the use of illegal drugs. However, it has not been shown in this present case that Ms. Carter's conduct was in violation of this compelling state interest. An email was sent out in April of 2007 by Principal Blake stating that she had overheard a rumor in the hallways that students may be wearing green in their hair or in other places to indicate that they were selling drugs. There is no evidence that this rumor was ever true or that it was ever widespread. There is only evidence that the faculty was aware of this rumor and not the students. In addition,
well, the council in Morse, nobody really knew what hits for Jesus meant either, yet that was enough for the Supreme Court to express the concern about drugs and allow the suppression of the speech.
Well, Your Honor, we submit that Morse v. Frederick is very distinguishable from the present case for three reasons. First, in Morse, although the actual meaning of the message was slightly unclear, it was clear that there was a drug-related meaning. Bong hits is a very clear drug reference, and the student in Morse provided no other explanation. However, in the present case, Ms. Carter has provided evidence that her hair was political and non-drug related speech. Second, in Morse, the principal only had moments to make a decision about what to do about the student's speech, whereas Principal Blake in the present case had 2 years of seeing Ms. Carter's hair before she decided to suspend Ms. Carter. If the interest was so compelling in preventing students from wearing green, and if those teachers and principal truly believed that green was in promotion of illegal drug use, Principal Blake certainly would have spoken to Ms. Carter about it when she first came to school with her hair green in September of 2007, and not 2 years later in September of 2009. And third, this court acknowledged in Morse v. Frederick that political speech is entirely different from non-political speech, and that political speech is at the core of what the First Amendment is designed to protect. Ms. Carter's speech was political, whereas the speech in Morse v. Frederick was not. And this court acknowledged that if Frederick's speech was political and perhaps advocated the legalization of drugs as opposed to the use of illegal drugs, it could have been an entirely different scenario, and the court may have found in favor of the student.
But if the school is seeing her green hair as advocating drug use or signaling that she's selling drugs, then that would take it out of the realm of political speech.
Well, Your Honor, we submit that that is not a legitimate claim by the school because neither of the teachers that complained to Principal Blake ever indicated that they believed that Ms. Carter's hair was advocating illegal drug use, and Principal Blake certainly did not suspend Ms. Carter because she believed her hair was advocating illegal drug use. Rather, Ms. Carter was suspended simply because her hair was in violation of the dress code. In addition, Ms. Carter was suspended 2 years after the email had been sent out, and by that time, 3/4 of the school had graduated since the time the rumor had first been heard. Thus, even if the rumor was ever true, there is no evidence that it was still true by the time that Ms. Carter was a senior in high school. Thus, Your Honors, we respectfully request that this honorable court affirm the Moot Circuit's decision, reversal of the district court, and remand this case for trial. Thank you.
Thank you. Rebuttal? Yes. May it please the court. In this rebuttal, I'll be addressing the issue of summary judgment and whether or not Ms. Carter's hairstyle was symbolic speech. In Anderson v. Liberty Lobby, this court held that summary judgment is appropriate unless there is a genuine issue as to a material fact. And the Sixth Circuit Court further clarified the standard in Arnett v. Myers by holding that the non-moving party may not simply rest upon its pleadings, but instead must prove that there is a genuine issue of fact by pointing to specific facts in the record. There are no genuine issues of fact in this case according to that standard. Ms. Carter's hairstyle was not symbolic speech. On either test, using either test, dispensed in Washington. Your Honor, there are many different interpretations that people could place onto Ms. Carter's hairstyle. For instance, thinking that she was protesting materialism at Christmas time, she added the coins. Furthermore, opposing counsel argued that the first prong of Spence v. Washington was met merely because Ms. Carter claims that she was attempting to advocate a particularized message. However, this court must use an objective standard in determining whether or not there's actual intent to convey a particularized message. Secondly, this petitioner's primary argument is that Ms. Carter's hairstyle did not convey a particularized message, not on the intent prong, as it were, but on the particularization. Opposing counsel did not address why Ms. Carter's hairstyle conveyed a particularized message. On the second part of Spence v. Washington, there must be adequate proof that it was likely, that there's a great likelihood that it be understood. Yet the factual record demonstrates no evidence that any of the school administrators or the other students ever understood Ms. Carter's message. And in fact, it demonstrates that none of the school administrators believed that it was because that it was advocacy against federal deficit spending, since they thought that she was actually advocating for illegal drug use. Therefore,
That's the right audience, is that the school administrators would have to understand the message.
Your Honor, my time is left. Can I briefly answer the question?
Yes.
Your Honor, whether or not the school administrators understood the message is not in and of itself determinative, but combined with the fact that no other students in the record understood Ms. Carter's alleged message, it does demonstrate that it was not likely to be understood. For all these reasons, this court should reverse the Court of Appeals decision and grant the school district's motion for summary judgment. Thank you.
Our counsel ready?
Yes, Your Honor.
If you will begin by stating your name.
Yes, Your Honor. Madam Chief Justice, and may it please the Court. My name is Andrew McNair, and I represent the petitioners in the case of Barr, the Tesla School District, Allison Blake, and Nathan Starr. At this point, I would like to request 2 minutes of rebuttal. Thank you, Your Honor. Your Honors, the petitioners respectfully urge this Court to overturn the holding of the U.S. Court of Appeals for 3 reasons. First, because Ms. Carter's hairstyle did not intend to convey a particularized message, and thus there was no great likelihood that such a message would be understood. Second, because the Tesla School District permissibly regulated Ms. Carter's hairstyle, pursuant to the broad discretion granted to school districts under Tinker and Morse. And thirdly, because the district court was correct in granting summary judgment in favor of the petitioners. At this point, would Your Honors like a brief recitation of facts?
Yes.
Very well. In August 2007, Ms. Carter, the respondent, dyed her hair green and grew it to a length below her shoulders. In December of the same year, she specifically drilled holes through 3 US $1 coins and weaved them through her new hairstyle. On September 23, 2009, a student began to play with Ms. Carter's hair, and Mr. Mansfield, the government teacher, noticed his distraction and sent Ms. Carter to the principal's office, to Ms. Blake. At the principal's office, Ms. Blake gave Ms. Carter the option of either desisting the practice of wearing her hair in this manner or facing suspension. At the school hearing on September 29, 2009, Ms. Carter abstained from mentioning any symbolic meaning purportedly behind her hairstyle, and she was suspended that day. Your Honor.
Does the record show what the actual disruption was? Was Mr. Mansfield distracted by the student playing with Ms. Carter's hair? Was it that the student playing with the hair was distracted? What was the actual disruption?
Your Honor, the disruption was the fact that Mr. Mansfield was administering instructions for an exam, and he states that he and the other students were distracted when the student began playing with Ms. Carter and respondent's hairstyle. So, Your Honors,
So, but that, of course, I guess the idea would be that Ms. Carter was responsible because she sat there with green hair. That would be why she would be responsible.
well, Your Honor, she facilitated this practice, and the record indicates that she had no issue with the student playing with her hair, and that she often played with her own hair. Your Honors, the first issue before the court here
Is
on
it a
case, if there exists a permissible regulation, then certainly a constitutional justification is present.
But I suspect that playing with your hair was material and substantial disruption. The principal's office would have more students in it than the classroom.
Well, in this case, Your Honor, it's reduced again to the circumstantial evidence in this particular case. So again, this court has the opportunity to expand its stare decisis on the issue. So in relation to the first point, under the writ of certiorari, the question before the court is whether the First Amendment protects the symbolic speech of students in the school environment. Now, in making a determination here, the court should turn to its holding in Spence versus Washington, which delineates a two-part criteria for symbolic speech.
Doesn't the students meet the first criteria? Isn't that pretty much just subjective what the speaker's intention was? And isn't it enough that she has clearly stated an intent to send a message regarding government spending? Doesn't that meet the Spence test's first part?
No, Your Honor, for two specific reasons. First, because Ms. Carter states three mutually exclusive justifications and only claims this symbolic purported message after litigation. The fact that these are mutually exclusive and that she claims a non-speech aspect and that she claims a speech aspect, but existing independently in one another.
Wouldn't that be an issue perhaps to clarify or resolve the trial as to what was really heard as opposed to the summary judgment?
Well, in this case, no, Your Honor, because Ms. Carter has not met the second aspect of the Spence test. There is no great likelihood that her message was going to be understood by others. Now, in Spence versus Washington, it was determined that there was an unequivocal meaning attached to the respondent's speech in that case. It was a United States flag inverted with a superimposed peace sign. Now, in that particular case, there are not comparable facts to the instant case, but there are interesting rules that apply here. Specifically, the fact that Ms. Carter's message was equivocal, was subject to different interpretations, demonstrates that it was not likely to be understood by others. The fact that the Tesla School District itself has misperceived Ms. Carter's hairstyle is denoting illicit drug sale, demonstrates that it did not have a salient outright message.
What would, in the Spence case, what about hanging the flag upside down with a peace sign would necessarily lead folks to believe it was a reaction to U.S. bombing in Cambodia or Kent State as opposed to just some other protest of the flag?
Well, Your Honor, specifically, this is relating to the general protest connotations here. Clearly, Spence didn't state that it was
Could you speak a little bit louder? I know we're at a disadvantage, but if you could just speak a little bit louder.
Yes, Your Honor. Specifically in that case, the question wasn't whether the fact that the respondent was protesting the Cambodian war was the issue. It was whether or not it was generally perceived that he was protesting some aspect of the United States foreign policy, which demonstrates the fact in light of the environment of that particular era. There were those political issues at the forefront, and it was widely